Good evening. This is Rahul Reddy. We're live here on April 18th at 5 p.m. Central Time. Every Tuesday, we bring in immigration updates from 5 p.m. Central Time to 6 p.m. and we take live questions. Emily, along with me is my business partner, Emily Neumann. Emily, what do we have today to discuss?
Today, we wanted to talk about a common issue that we're asked about: is self-employment allowed using an EAD while the 485 is pending? So what do you need to know about whether that's possible? What are the ramifications of doing that? We also get a lot of questions from H1B holders who want to purchase and rent out properties. What are the considerations that you need to think about if you're going to rent out a home or other property? And then moving from H1B to H4 EAD, we're seeing this a lot right now in the job loss situation. And for people where there's a couple that both have H1Bs, there's an option for one person to move to the H4, and assuming the spouse has the I-140, they can get the EAD along with it. What is the best way to accomplish that change of status to make sure that there's no gap in employment authorization? And last, H1B amendments. We're contacted a lot when people are promoted, which is a great thing, and they always want to know, how is this going to impact my H1B? Do I need to file an amendment? And so we'll talk about what the analysis is to determine whether an amendment is always required for a promotion situation. So going back to self-employment, you've got your EAD, your 485 is pending. Is it allowed? Does it have to be in the same field? Do you have to be in the same job? What are the considerations there?
Emily, self-employment is definitely allowed, but of course they have to work in the same field. If they're in the IT profession, they should be working only in the IT profession. They can't be an Uber driver for sure. But when they want to do self-employment, though, the USCIS may test the genuinity whether or not there is a self-employment, or is it this guy just saying that he's self-employed only to keep the 485 alive? So definitely, I would request people who wants to move into self-employment to consult a lawyer. Now, do they need to form a corporation? Do they need to do the DBA? Yeah, it would be better if they form a corporation or a DBA. That would be better. Is it absolutely required? No, it's not required. It is definitely recommended. It's not required. I mean, have you come across a situation where you're faced in the 485 interviews where people were being self-employed, and did you ever face the USCIS official asking the questions, and what was the response to it?
Yeah, it's come up a couple of times in different situations. So in one situation, the client actually had ported their job to self-employment, and they submitted a supplement J that was filled out by their company. They had incorporated their own company that was in the same line of work that they were doing on the I-140 and labor certification that supported that 485. So we submitted that supplement J. We also put together a packet of documents to basically show that this is a legitimate company. The company had the FEIN numbers given by the IRS. We had that letter. We had bank statements. We had the company website printed out and invoices showing that the company really was doing business. And we brought all that to the interview. The officer really didn't have any questions about it, didn't have a hard time at all, and approved the green card. So that's one scenario. Another scenario that comes up is when people are using the EAD to work on the side while they're continuing their job offer with their main employer that's sponsoring the green card. And that one seems to be that a lot of officers get really confused about. They don't think people can work two jobs. They think it's impossible. So they always question, well, how are you getting paid for these two companies? How did you find this second job? How are you able to do more than one job? And they then come with a request for evidence asking for income tax returns and W-2s and payroll records and those sorts of things. So you might want to be prepared if you are called in for an interview and you're working for multiple employers, including your own self-employment while you're still being sponsored by your main employer. Bring some of those additional documents, but definitely consult with a lawyer if you're called in for an interview in that situation.
Maybe if I'm the main applicant and I want to work for my wife, can she employ me? Can she sign the 485J supplement? Isn't there a restriction in the green card that it cannot be sponsored by the relatives? Is that applicable to the 485J supplement?
Yeah, the restriction on being sponsored by a relative is actually during the labor certification process, and it's not that you can't do it. You just have to disclose that family relationship on the labor certification, and then possibly be audited and provide documentation that the person being sponsored had no part of the labor certification process, and it really is a bona fide or legitimate job opportunity. But once you get to the 485 stage and you've passed your 180 days and you have your EAD card, you really can work for any employer as long as it's in the same or similar job occupation. So yes, it is possible for a spouse to start a company and to be the actual sponsor, that company to be the sponsor of the 485 moving forward after that 180-day mark.
Let's move on to the next topic, Emily. If I'm in H1B and I don't have an employment authorization document, can I rent my second home, and can I get the lease, and can I do that? I mean, I'm getting an income and I'm not on EAD. Can I have a second income as a rental income, renting my second home? Will that be a problem?
Yes, it is possible to do that. What the restriction is on working for an employer that you do not have work authorization for, renting out your home and getting income from that isn't really work. It's utilizing your property and getting a lease, and that's about all you're doing with that. So you're not spending your time as a job being a property manager or leasing out multiple rentals or running Airbnbs or things like that. So we're talking about one or two properties where you spend just a tiny percentage of your time just getting the lease up and running and getting payments. That's kind of similar to investing in the stock market. You spend a small percentage of your time researching, trying to decide what stock to buy, then you buy it, and then you get the income from that if the stock is successful. That's the same way I look at rental properties, as long as it's a small number of them. If you're starting to rent out 10 different properties to where you're constantly going to different houses and being the plumber and being the electrician and fixing air conditioning and beating down doors to collect rent, that gets a little bit beyond, I think, passive income, and you're more active at that point. And I think that's where you might have a problem.
Anything else to discuss, Emily, before we move to the third topic?
Nope, I think we can move on.
People are interested in moving from H1B to H4 EAD nowadays, because when both people have H1B, both people have I-140 approval, when somebody loses a job, preferably the best option obviously is to move on to the H4 plus EAD, Emily. And people are confused, paranoid, especially when they already have a job and they want to move to the H4 EAD. Do they need to put the future date? For example, the H4 will be approved somewhere in 6 months down the line. So do they need to put the October 1st start date, or can they put May 1st start date? If they put May 1st start date, do they have to stop working on May 1st for the H1B employer, or can they continue working and after May 1st, even though they put the May 1st start date on the H4?
Yeah, I mean, I think that effective date on the I-539 form is not controlling your status. So just because you put a May 1st start date does not mean you are then in H4 status when May 1st happens, if the I-539 has not yet been approved yet. So as long as you are, your H1B, I-797 is still valid and you're still working for that employer, I don't see any reason that you have to stop working based on the effective date that you requested on the I-539 when the I-539 is still not approved yet. Once it's approved, then yes, you have to make sure you have the EAD approved at the same time, which by and large is happening. So we're not seeing as many problems with people converting to H4 EAD status compared to what we were during COVID in the last 3 years.
And Emily, people ask question to me, hey, what if the H4 is approved and the EAD is not approved and I want to continue working for the job? Can they do the Margarita Switch? Can you explain what this Margarita Switch is? in that particular scenario?
Yeah, so at that point, they've got an H1B approval notice that's valid with an I-94, but they're not in H1B status anymore because they've received a new approval notice, putting them in H4 status. If they want to go back to H1B and that employer is still offering them that job, same job that was listed on the H1B petition, same salary, same work location and everything, yeah, you can do the Margarita Switch, take a quick trip to Canada or Mexico for less than 30 days. And when you're coming back, now you're going to show the H1B approval notice, assuming that your I-94 on that approval notice has not expired yet. Then you'll be put back in H1B status, even though you were just approved for H4 status. You're getting a new I-94 that converts you back to H1B. And then later, when your EAD gets approved, if you actually want to go back to H4, you can do the Margarita Switch again because you already have an H4 approval notice with a valid I-94. And you don't need a visa stamp, a US visa stamp, to re-enter in either of those scenarios. You can use your expired stamp or a stamp that was in another status if you had a change of status.
Looks like you have too much Margarita, Emily. I don't have the H1B stamping. I don't have the H4 stamping in my passport. How can I do that?
Yeah, that's the automatic visa revalidation. We call it the Margarita Switch, but that's the technical term, automatic visa revalidation. Basically, it treats an expired visa the moment you're entering the US as being automatically revalidated at that moment to allow you to enter, and then it goes away once you're entered. So yes, you can use an expired H1B stamp and a valid I-797 approval notice for H1B and still come back into the US as long as you've been for less than 30 days, only Canada or Mexico, and you have not gone for stamping in Canada or Mexico. Same thing getting back to H4, if you have that I-797 approval notice for H4 that has the I-94 on it that is not yet expired, you can go to Mexico, you can come back. Even if you have an H1B stamp in your passport, you can use that H1B stamp. They revalidate it and treat it as if it's an H4 stamp at the moment you're entering, and you come back into H4 status.
Emily, on the amendments of the H1B, we know that if the people move out of the geographical location, especially if they're beyond 50 miles or 60 miles from where they are located at, they need to file an amendment of the H1B, which everybody knows it. What about the promotions? Does every promotion require an amendment in the H1B or only certain promotion? What is the black and white? What is the gray area? Can you explain what kind of promotions you feel requires an amendment? What kind of promotion you feel does not require an amendment? What kind of promotion will you think so that you need to discuss with the HR and the employee and decide whether or not it requires an amendment?
Yeah, the black and white rule is if the change is a material change to the terms and conditions of your employment that were listed on your H1B petition, then an amendment is required. That leaves us to question, okay, what is a material change? Well, it can be a change in salary, a drastic change in salary, a drastic change in job duties, change in location, we've already covered, but not every promotion is such a drastic change that it requires an amendment. It's not material. Many times clients will call me and say, hey, I just got a promotion. I'm basically doing the exact same job duties, but I got a raise. Well, that's not a material change because it's just part of your normal career progression. Another client will call and say, yes, I got a promotion. I'm doing mostly the same job duties. I have maybe a little bit more supervisory duties now, but I'm still supervising the same types of people that for the job I was doing before. I think in most situations that may not necessarily require an amendment. It really is a case-by-case analysis. And we look to what is the difference in salary? Does the promotion, what is the difference in the job description? We really put the old description and the new description side by side and figure out how different is it. If it's very different, then it might need an amendment. But if it's mostly the same, probably not. There's not really a bright line test on that. It's kind of a gray area. So you do have to look at it on a case-by-case basis. So anytime that does come up, I would recommend HR and talking to an attorney to make sure that it's not going to be a problem in the future if you choose not to amend. There's some situations where you may want to amend the H1B due to a promotion, and that can come up where you're planning on filing a perm labor certification for someone and you want to count the experience gained with the company but in a different job. A lot of times it's easier to do that when we have an amendment filed. Now we have a set start and end date for the previous job and the new job, and we can show that they are materially different, which allows you to use that prior experience in the perm application, even though it's kind of a hassle to go through the amendment process of the H1B.
Any other announcement, Emily, before we go and look into the questions and answers?
Nope, I think we can move to taking questions.
The question that came in, very interesting question from VJ is, I have not received the H4 EAD extension receipt. Can the attorney provide a letter stating H4 EAD extension has been filed, waiting for the approval so I can fall into the automatic extension? Automatic extension is speaking about the 540-day rule. First of all, if you get a receipt notice of the H4, and you said H4 EAD extension, so I'm assuming that your H4 is already extended. You don't have the H4 EAD receipt notice. You can do one thing. You can always look into the cash check, and based on that, you can find the receipt notice. That's one thing that you can do. The second thing you can do is that, hey, if you still have time, file another extension. That'll be easy. Sometimes if the receipt notice is misplaced, file another extension. The problem is solved if that happens.
Srinivas says, one of my friends got an H1B back in 2013 and got the visa stamped but never actually traveled to the US and wants to know, can he now apply for an H1B with a new employer without going through the lottery? And the answer is yes. In order to be considered counted in the cap, you either had to have been granted a change of status to H1B or applied for the visa stamp and received the visa stamp. Either of those will allow you to be not subject to the cap in the future. So he could have a new employer file an H1B petition now that is not subject to the cap, get that approved, go for visa stamping with that employer, and then come into the US for a fresh 6 years.
Achilles has this question. Can he file the extension for the taxes under H1B? Yeah, absolutely you can. No problem with it.
VM says, I got my green card and want to work for my client directly, but my employer says I can't do that. I thought we could work for anyone after getting the green card. Please advise. So you're correct from an immigration standpoint. You can work for anyone once you have your green card. As Rahul always says, you can be the Microsoft CEO or you can flip burgers at McDonald's. Either of those is perfectly fine for a green card holder. It's possible that your company and the client have a contract that does not allow the client to kind of steal employees from the company. So that may be part of the issue, or there may be some sort of non-compete agreement that needs to be worked out. So it's not really an immigration issue, but it might be another contract issue that wouldn't allow you to work for that client.
Emily, I need some discussion with you with regards to the question that is coming from Vikram Nalamotu. Can my spouse travel an EAD AP while the primary H1B applicant is no longer an H1B, is in the process of finding a job on EAD? What documents to carry for the port of entry? I think so the main problem, first of all, I do not want his wife to travel. The reason is that he does not have a job. If there is a question that is going to be faced at the time of entry, it's a problem. But we need to resolve the main problem for this person. Can a person be unemployed on the EAD and the 485? Will the 485 will be approved? What are the solutions for it though? I mean, if he can't find a job, can his wife employ him? Can he be self-employed? What are the options that are available? Can a person be completely unemployed and no offer and still get the green card on the 485 application?
Yeah, for the last question, no. So the 485 is always based on an offer of employment, which is not necessarily the same thing as actual employment. But you do always have to have a valid job offer. So if he does not have a job right now, although there is a 60-day grace period for H1B, there is no grace period for the 485 and that EAD. So you need to be figuring out, how am I going to continue to support this I-485 application? And that's got to be through either a new job offer that's in a similar line of similar occupation, or if the spouse has an EAD and is able to start a company, that company could be the sponsor. Or you could do self-employment, as we talked about earlier, decide to start your own company and be doing the same type of work that you were originally sponsored for. But all of those are looked at with some skepticism by officers. So definitely you should talk to a qualified immigration attorney, get that case reviewed before you take any of those actions.
Questions from Srikanth Yarlagadda. His EB3 485 date is not current. He already completed his 485 interview. Can he expect another interview in the next 2 to 3 years? Typically not. 95% of the time you will not be interviewed again, but is there a chance for it? Yes, there is 5% chance that you may be interviewed again. I definitely want you to prepare with the income tax returns, pay stubs. If needed, your company needs to give you the 485J supplement again. If you're not working for the same company that filed for the 485 application, they still need to give it again. So be prepared for it, but mostly you may not need to go for the interview.
GK wants to know, if I travel while my AP renewal is pending, will it be denied? And if yes, when I return to the US, should I refile the renewal? So this is important to mention that we're talking about a renewal situation here. So I'm assuming you have a valid AP that has not yet expired, and then you filed your renewal early and it's still pending, but you're planning to travel on the old AP and come back before the old AP expires. In that situation, the renewal is not supposed to be denied because you had a valid AP prior to that, before when you left and came back. So it's not necessary to refile that renewal.
DAD has this question, Dheeraj and Didipya. Can I file a EB1C with a functional manager with nobody reporting? I'm on H1B, and what are the documentation required to submit to get the I-140 approval? One thing, I'm assuming that you meet the requirement that you have worked for this company outside the country for an year before you came into the United States. That's one requirement for the EB1C. If you meet the requirement, yes, technically, even though you don't have any reportees, you may be eligible for a functional manager, but the bar is very high. So I definitely request you that you contact an immigration lawyer, give all the job description and the position in which you are in. For example, if you are a CEO of a company that has been, or CTO of a company that has, that probably has $50 million or $100 million turnover, and it's a technology company, yeah, definitely you may qualify under functional manager, even if nobody is reporting to you. That may qualify, but the bar is very high for functional manager. It's not that easy. Just because you're a software engineer or a senior software engineer or an architect, it may not automatically qualify. But yeah, a CTO, Chief Technical Officer, probably it's easier for you to qualify, but an architect may not be easy to qualify. That's my opinion, MD. What do you say?
Yeah, I would agree with that. I mean, for the functional manager, you have to show that there is a defined function that you're in charge of, that function is essential to the company, that you are at a senior level with respect to that function in the company, and that you have discretion over the day-to-day operations of the function, and most importantly, that you're not doing the function yourself. That's where you get into the situation of a software engineering manager or an architect that is actually doing the software engineering and also managing. Then you've got to look into what percentage of time is the person spending on managing versus doing, and is it really sufficient to qualify for that functional manager?
Achilles has some interesting question. He's trying to become an immigration lawyer, seems to be, that my friend has a full remote job from home. And if the prevailing wage is filed, can he change the city? Typically, though, when they file a prevailing wage, so the companies will file based on the location of the company, even though this person is working remotely. Let's say, for example, the company is in California and you're working in Florida, they will typically file a prevailing wage in California itself, though. So definitely, if he changes the city in that case, though, he doesn't need to file a prevailing wage again, doesn't need to file the labor certification. Some of these consulting companies, most of the consulting companies will have a provision that the person could be working in unanticipated locations, though. So just because if you work for a consulting company, if you have that provision in the labor certification, then definitely it's not a problem. You can change the city. It will not create any problem.
Harry says, is having an EAD sufficient to do an Airbnb, or should the status be converted from H1B to AOS in addition to that? Well, ultimately, if you're using the EAD, you're no longer in H1B status. The two don't go together. You can't be both in H1B status and be working somewhere else pursuant to an EAD, because by working for somewhere else, you're violating your H1B status. So simply by using the EAD, you're no longer in H1B status. Now you're in adjustment of status.
Gulam Raja has this question. My L1B blanket visa stamp got expired and the petition is valid until 2024. And if I go back to stamping, will they start adjudicating application for the specialized knowledge again? Unfortunately, yes. We have seen that in the consulate, they re-adjudicate the entire application again and again. So they will test you about the specialized knowledge there again. So definitely L1B, every time you go, it's like keeping your head in a lion's mouth to see, will it bite, will it not bite? It's definitely risky for L1B, especially for blanket.
Conda says, my I-140 was approved back in March of 2022, but the case status shows that it was sent to the Department of State, and it's been 398 days. What does that mean? So number one question would be, is your priority date current? I'm assuming it's not. And number two, when the company files an I-140 petition, there's a box they have to check that mentions whether you're intending to file adjustment of status from within the U.S., or will you consular process your green card? If they check the box for consular process, once that I-140 petition is approved by USCIS, they will send that file to the Department of State, because Department of State is in charge of the consular process. So that means your file gets sent to the National Visa Center, or NVC, where they're going to keep it on hold until your priority date becomes current. They will then reach out to you, ask you to fill out the immigrant visa application online. They will have you submit your supporting documents to the National Visa Center, and then once they receive all of your documents, they will then send the file to the consulate in your home country, and that consulate will schedule you for a green card interview. Now, if the company selected consular processing, but you happen to be in the U.S. when your priority date is current and you want to file adjustment of status instead, that is fine. You can still file adjustment of status, just file it. You don't have to take any extra steps. If it's the other way around, where your I-140 mentions you are going to file adjustment of status, but now you want to switch it to consular processing, then you have to go through an extra step of filing an I-824 application, which will have USCIS notify the consulate that you intend to pursue consular processing instead of adjustment of status.
Sidhu Reddy has this question. Currently, filed an adjustment of status in January of 2023. When can I expect the EAD? How long the EAD and AP will be valid? Typically, EAD and AP may be approved anywhere between 3 months, and I'm not going to tell the end of the date right now. I'll explain it. EAD will be approved anywhere between 3 months to about 8 months. That's a period of time. EAD is typically, most 99% of the time, valid for 2 years. Advanced parole, mostly, if it's filed EAD and AP together, about 70% of the time it will be approved along with the EAD. The validity period will be the same as the EAD, which is going to be 2 years. The 2 years is from the time it's been approved all the way to 2 years, not the time you filed, but the time it's been approved. Now, when it comes to the advanced parole, I said 30% of the time, I don't know why these stupid officers are not adjudicating the advanced parole at the same time when they do the EAD. They are adjudicating at a different time. And if they do so, most of the time, they are giving only 1 year validity for the advanced parole. And that 1 year validity will be from the day it has been approved, not from the day it's been filed.
Ditya says, can I transfer my approved I-140 based on a mechanical engineering job to a software-related job? Well, there's not really a way to transfer an approved I-140. So in order to accomplish a career change from mechanical engineering into software engineering, you need to be offered a new job that's in software engineering, and that new employer has to file a perm labor certification, just like you went through before. And on the perm labor certification, yes, an employer can say that I'm offering this person a software engineering position, and I will accept either a degree in computer science or mechanical engineering, software engineering. They can list whatever fields of engineering might qualify someone for that job. So yes, it is possible to switch careers for your I-140 by going through the perm process again. And we don't see much of an issue with sponsoring someone that has a mechanical engineering degree for a software engineering type of role.
My 485 has been filed in 2020. Can I change my location in the same team and same role? Tarun Bajaj from Facebook. Absolutely, you can. You do not require to file a perm labor I-140 or anything. You do not require to file a 485J supplement at all, because it's been, you filed the 485 application, it's been more than 6 months. You're absolutely fine since you're working within the similar profession for which you filed the 485. You have no problem with it. Abhijit Sen has this question. My wife is traveling to Netherlands and a H1B visa. This is a visa that has been issued to certain countries of European countries, a group of European countries that I think so Austria, Netherlands, and certain other countries will come in. And she's going to return back an advanced parole. What are the documents that she needs to carry? Well, I don't have to explain that you need to carry the passport, which, I don't have to explain that, but you also need to carry the advanced parole. Make sure if it's an EAD, does it have an advanced parole on it? Make sure you check it. Sometimes people ignore it. They're only approving EAD without advanced parole. Check that. Make sure that advanced parole is there. If not, there should be a paper approval that has a picture of you. If you haven't, those two things are absolutely needed. 485 receipt notice, just keep a copy of it just in case if they ask any question. But other than those things, you do not have to worry about carrying any other documents. Now, are there chances that your wife could be taken to the secondary inspection? What is a secondary inspection? When you come to the airport, the officer will be there. He will look into the documents. Okay, you need a secondary inspection. Then wait here. Then the CBP officer coming, with all the guns and everything. And they will take you to a small room to ask some extra questions, though. But don't worry about it. This happens with a lot of advanced parole people. It is common. You're not criminal. You didn't violate anything. It's just that some of the airport facilities do not have the processing facilities for the advanced parole. They take you to a small room, and then within about 5 to 10 minutes, or sometimes even it may take an half an hour for you to let you go outside the airport. That's very common for advanced parole. Don't be panicked when the security person comes in and then, hey, can you accompany me to the small room? Don't be worried about it.
Verinda says the H1B, H4, and H4 EAD were all filed together in premium processing, but only the H1B got approved within the 15 days. Is there any suggestion to expedite the H4 EAD processing? So there was an issue. USCIS had some kind of glitch that was causing this, and they are aware of it. We really haven't seen it come up recently. But basically, your employer or their attorney can reach out to the premium processing unit to ask for an update on the H4 and H4 EAD and remind them that the policy is that they should all be bundled together and approved together when they're all filed together in premium.
Quota Imma has this question. how many months early can we file a H1B extension? Is if it's good approach to take the file to file it early. Yeah, you can file within 180 days. You can file the H1B extension. I definitely would like to get the result before the expiration of the I-94. Why? Here's the reason though. Let's say, for example, your H1B is expiring in October of 2022, and you wait until August, you file the extension, and you wait until December or January to get the result. And what if there is a denial? Then what will happen? You may have to leave the country, go outside the country, and get the H1B approved and come back. That's the danger you face. But if you file the H1B extension right now, you get the result, let's say in August, you get the approval. Well, good, you dance around, you're good. Your tension is over for the next 3 years. You don't have to worry about, you don't have to look into immigration lawyer all the time for the next 3 years. You're good, that's good. However, if there is a denial, oops, what's going to happen? You got the denial in August, but your I-94 was expiring in October. Can you work until October? Absolutely, yes. You can work until October. And then guess what? You can file one more extension. You get the second chance to file one more extension. So I normally recommend people to get the result before the I-94 expires, because it will give an opportunity just in case if there is a denial, there is a problem, to rectify.
Not sure if we're having technical difficulties here, but another question that we had from Arun. My priority date is July 2012 in EB2, but I have I-140s approved in both EB2 and EB3. Already filed the adjustment of status in EB2 last year and got the EAD and AP. But on the EB3 I-140 approval, the wrong priority date is there. So he wants to know, can he interfile when the date becomes current for EB3, even though that approval notice has the wrong priority date? Technically, yes, you can. You may have to file it multiple times because you might confuse the officer when they see that wrong date on the approval notice. So what I would probably do is over the next weeks or months while you're waiting for the EB3 date to become current, to go ahead and request the correction of that approval notice, of your I-140 approval notice, so you can get it with the correct date. Or do a FOIA, Freedom of Information Act, request to get a copy of your I-140 petition. That copy should show what priority date was actually assigned to that I-140, and you could use that to interfile instead of using the approval notice with the wrong date.
Question with regards to whether a company can file a home and I-140 application when the person moves to the H4, especially they're crossing their 6 years, they're moving to H4. Can the company file that I-140 and labor certification I-140 when you're not working for that company? The answer is yes. They can file an I-140 home and I-140 even though you're not working for the company. Absolutely not a problem.
Gulam wants to know if an L1 under the blanket is indefinite, or is it also for a 5-year maximum for L1B? There is a 5-year limit to L1B, so whether it's under a blanket or not, the rules are the same. L1B time maxes out at 5 years, L1A time maxes out at 7 years. The difference with the blanket is that you can apply directly at the consulate for the visa without having to file an I-129 petition with the Immigration Service. So you'll get that visa stamp in your passport. Your visa stamp may also be given for 5 years, depending on the reciprocity between your country and the U.S., but it will have a PED, or petition expiration date, on it. And that's the date your I-129S expires. That's what you take to the consulate to get your visa under the blanket. So you have to go by that PED date, not the visa stamp date, when you're looking at when your status actually expires.
Question from Rajan Bamburu. I have an EB3 I-140 approval after completing 180 days after it's approved. Can I leave the country and can I come back after 6 years or 10 years? That's a question. A lot of people ask this question. The answer is simple. You can come back within 90 years, not after 90 years from now. And people ask me the question, why after 90 years I can't come? Well, I'm expecting you to be dead because you're between 20 and 30, so I'm not expecting you to live that long. That's the reason why I say 90 years. Absolutely, you can come back, no problem with it at any point of time. There is no 6-year limit. There is no 10-year limit. There is no limit. There is no limit that you have to come back within the H1B period. You can absolutely come at any point of time.
Kieran says, can I apply for an AP extension on my own, or do I need a lawyer? Well, I think there's a difference between whether you can do something or whether you should do something. So yes, anyone can file their own applications. You can file the 485 yourself. You can file an I-539 yourself. You can file the EAD and AP extensions yourself. Should you do that? Well, a lawyer can make sure it's done correctly in order so that it goes to the right service center, the filing fees are correct, and they can help when there's a problem that happens versus you navigating that process on your own. And the AP form is very simple, but it's also very confusing because it's used for multiple different types of travel documents. So it can be confusing on what part you have to fill out, what part shouldn't you fill out, what do you need to put here and there. So for that reason, I'm a lawyer, so I do, of course, recommend you use a lawyer for that.
Anu has this question. In the event of a divorce, can a person use the ex-husband's priority date? Can that be ported to this particular person who got divorced when the priority date belongs to the ex-husband? The answer is simply no. You cannot port the priority date of your ex-husband. Absolutely, you cannot. Prithvi has this question. He has 10 rental properties in Orlando on H1B. Congrats, that's nice, good job. Emily's also trying to do something like that. She couldn't get there. You already have it, that's congrats. Now, is there any way to fast track the green card process? His firm and I-140 is in the process as a civil engineer. No, the answer is no. There is something called an investor visa called EB1. The requirement of that should be that you must invest a particular amount of money. It's anywhere between $900,000 to about $1.8 million. But then it has to create 10 employment opportunities. So rental properties normally don't have, even though you have 10 properties, you don't have 10 people working for your company. But there are some alternatives. You may want to discuss about EB5 option with a lawyer to see if you want to go in that particular path. And what are the pluses and minuses if you want to go in EB5 path you may. But just because you have 10 properties, you're not automatically qualified to get the speed up the green card process or eligible for any other different process. Now, having said that, there are some country nationals that may be eligible for a special kind of visas. Under your circumstances, probably E2 is one thing that people may be eligible for, but unfortunately, Indian nationals are not eligible for E2. If you belong to some other countries like Pakistan, you would have been eligible for E2, but unfortunately not for Indian nationals.
Zena has a family member suffering from a medical issue and has to take a very costly medication, but the manufacturer for that medication offers financial assistance and wants to know if she can take that financial assistance. Will it cause any problem for the green card approval? So there is an issue with green card applications for all employment-based green card applicants. They have to prove that they will not be a public charge or go on welfare. They have to prove they're able to support themselves. So yes, that rule applies. However, what they look at to determine whether you're a public charge is whether you've used any public benefits. Have you actually used government assistance? That kind of welfare. So this is provided by a private company, so it does not fall under the public charge rule. So I don't see any issues with that for the green card or H4 extensions.
Smita Shekhar has this question. If I get a 221G during my H1B stamping, can I still come back on US using my advanced parole? Yes and no to that answer, though, depending on the 221G and the issues that arise there, you could be coming back on advanced parole. I would definitely, if you get a 221G, I would definitely check with a lawyer to make sure that when you come back, it's going to be fine. My main question to you is that why are you going for stamping? That's the first question that I have. You don't need to go for stamping. But anyway, people like immigration lawyers, so there's nothing I can do about it. Funny TV has this question. My priority date is June 15, 2012 in EB3 and visa bulletin for EB3. Final action date is also the same. Am I eligible to get picked? It has to be 1 day earlier though. It cannot be on the same day. If the priority date is June 15, 2012 and your priority date is June 15, 2012, oops, you missed out by 1 day, buddy. Unfortunately, you missed out by 1 day. No, they can't grant the green card based on that.
Rajan wants to know, if I get the EB2 NIW approval and have proved substantial benefit to the United States, during a subsequent EB1A, will the same argument be useful for EB1A in getting the waiver of the labor certification? Yes and no. So the NIW, you're showing that it's in the national interest for the labor certification process to be waived. There's no requirement for an EB1A that you have to show that anything is in the national interest. For the EB1A, you just have to show that you have extraordinary ability in your field. So they're very different basic requirements, but a lot of the documentation is similar. So you may be able to reuse some of the reference letters and things like that that you used for your NIW to qualify for the EB1A, but just because your job is in the national interest does not mean you qualify for EB1A. You've got to have extraordinary ability, and you don't need to prove that it's in the national interest.
A question from Alok Tripathi. EB3 filed in 2020, downgrade case, got EAD. If I change the employer, now will my 485 remain stuck with the EB3? There won't be any way to upgrade back to EB2. Am I right? Alok, there are two options. One, for sure, I know that you're going to be able to convert into EB2. One, if your new company is going to file another form and I-140, you definitely can get into EB2. Now, there is another controversial method. We used it, it worked. If you move to company B and previous company has an I-140 approval and EB2, you can try to use that. We have been successful in it in most of the times. So you can, when you file the 485J supplement with the current company, instead of using the EB3, use the EB2 and tell that I want to get adjudicated in EB2. I have an I-140 approval in EB2. We have seen time and time again USCIS approving the 485 under the EB2, even though the person never filed under EB2, and the company that has the EB2 I-140 has never filed the 485J supplement under EB2. We have seen that approvals and no problem with it. But we don't know if they will revert back on that one.
HF says, I have a 485 pending under EB2 based on a job with employer A, and that was filed while I was working with employer B. Now employer B is ready to file the 485 under EB3, but they're asking me to withdraw the previous 485, saying I can't have two 485s at the same time. Is this correct? No, it's not correct. So first, I'm assuming that company B now has a labor certification approved for you that qualifies for either EB2 or EB3, and they're filed the I-140 and EB3, and the EB3 date is current. So yes, you can file a second 485. Never had any issues of having two I-485s filed at the same time. They will, whenever they're ready to approve one, they'll either administratively close the other one, or they'll ask you at the interview, hey, do you want us to close this one because we're ready to approve the other one? Or sometimes they'll send a request for evidence asking for you to let them know which one you want to proceed with. But no problem. There's no restriction on filing only one 485 at a time.
Question from the question that came from Tarun Saidana. Can multiple employers file perm application EB2? Will that cause any problem? Absolutely not. You can. I meant to say sorry. I take back. When I meant to say was that multiple companies can file EB2s, no problem. What I meant was that there will not be any problem if multiple companies file under EB2.
Talk to San says, what will be the impact if someone does not file the AP extension for the advanced parole? There's no impact on your pending 485 or on your status. That being said, we still recommend it. Number one, it's free. There's no filing fee for it. And number two, it's good to have that in your back pocket in case you need to travel for an emergency situation and you can't get a visa appointment to come back, or you don't have your underlying non-immigrant status anymore and you have to travel. Because if you travel without an advanced parole and you don't have any underlying status, you're going to abandon your 485 when you leave. Or if you travel planning to, you have your non-immigrant status and you're planning on going for stamping, but what if stamping gets delayed, 221G, or what if you can't get an appointment? What if COVID happens again and you get stuck there? So for all those reasons, even though technically you don't have to have an AP just because you have a 485 pending, we pretty much recommend it for everybody, unless you're in some category where you were out of status prior to filing or you were undocumented or something like that, and then you cannot use an AP to travel. But for most employment-based applicants, we always recommend keeping a valid AP.
Question from Sanjeev Gupta. How advanced can I file an I-131 advanced parole? Is it 120 days, 180 days? It is 180 days, not 120 days.
Have you filed any before the 180 days and had any issues?
Good question, Emily. I have had filed a lot of cases right now before 180 days. I haven't had any denials yet, though. Could it be denied if I file before 180 days? Well, there's a chance for it, but I'm taking the chance because nowadays it's taking some of the advanced paroles for 17 months for them to issue, and they're telling only to file 180 days. I'm filing in advance, testing the market to see, and had no problems in getting the approval when I filed way before.
Harish says, I submitted a supplement J to switch from EB3 to EB2 last year as part of an RFE, but never got a receipt notice for that supplement J. Is that normal? Yeah, it can be normal because it was submitted as part of an RFE versus filing it separately through the 485J filing location. And also if that RFE came from the local office, the local field office, we see a lot of times that they don't issue a receipt for that. You can always resubmit it or wait and see if they send another RFE, depending on how far out your date is going to be current, and submit it again.
Emily, let's discuss on this priority date. This is the hard discussion that goes on. What movement of the priority date? They said the EB1 India is going to backtrack. That's one thing. The State Department also indicated that there will be a rest of the world backlog for EB2 and probably EB3 also. What is the impact on it? What do you expect that on Indians in particularly, especially EB1? How far do you think so it is going to move? But what about the anticipation of moving the dates forward or backward, especially for Indian nationals? Based on the description what the State Department has given that the rest of the world will be backlogged, does it mean it's going to impact Indians?
Yeah, I mean, basically, whenever the rest of the world backlogs, that means they're using up all of the green cards that are available, which means there's no spillover available. So normally the rule is when EB2 rest of world doesn't use all of their green cards, those extra green cards go to whichever country is the most backlogged, which is generally going to be EB2 India. So India historically gets a lot of extra green cards either from the spill down from EB1 or the spill across from the rest of the world. Now they're seeing EB1 is retrogressing. Now they're saying EB2 rest of world is retrogressing. EB3 rest of world is retrogressing. That means India is literally stuck with these 7%. They're not getting any extra. There's not going to be any spill down from EB1. No extras coming from EB2 rest of world either, which means EB2 is of India is not going to be moving forward. You know, if you have to look at what the visa bulletin was doing prior to COVID, because we all kind of forgot that, because during COVID with October 2020, we had that big jump and then the dates went forward and then they went back, but they were still moving forward as they were lifting that retrogression. Well, now we're basically back to where we were before October 20, and those dates were retrogressed. EB1 was retrogressed for a very long time. I'm trying to find my, I had a blog post that has all of the statistics of that. But of course, because everybody's retrogressed in EB2, everyone's asking right now, how can I get into EB1? So they're filing the EB1A, or they're going outside the country for a year to come back on EB1C, which those are all possible, but they're going to be recapturing or retaining the priority date from 2014 or 2013. That means they're going to jump ahead in line of all the people that filed their EB1 in 2022 or 2023. So it's just going to keep getting worse. I don't see any positive outlook here at all unless either Congress does something or the Biden administration does some sort of executive action.
And of course, on the topic of the Congress, though, there is a HR 1535 bill that is being proposed by the Republican congressman from Indiana, supported by Raja Krishnamurthy, Democratic congressman from Illinois. We want you to urge the congressperson to pass this legislation, and we have provided a draft of this letter for you. The link is provided below. Please keep writing. Whoever is waiting for the green card, whoever wants to apply for the green card, you need to write these letters, guys. There's also another letter that we have drafted. It's been there for a long period of time, that if the Congress does not act, can the administration not count the family members? In that way, they're going to double, more than double the number of the green cards that are available. Yes, they can do it. We have drafted that letter too. That link is provided there. Please write these letters. Tell your stories to the congressman, tell your stories to the administration, so that they pass the legislation in an alternative if they would actually not count the family members. Now, what about this legislation of 1535? What it says is that the green cards that have been wasted, approximately around 400,000 green cards have been wasted, they want to use that according to the law. If this bill is passed, definitely it's going to reduce the backlog. Is it going to eliminate the entire backlog? Not. Is it the permanent solution that I would like to have it? No. But at least it's going to be temporary relief. So if you're applying for the green card right now, will it benefit? Maybe not. But if you're going to kick out 400,000 people in front of your line, you kick them out by giving the green card, you will be ahead of the line. So definitely for those people who want to apply, those people who are on the line, it will help. Please support this legislation, write the letters, write your congressman, and also try to tell the administration, if the Congress is not willing to do anything, just stop counting the family members. The law does not say to count the family members. Why are they counting? In the H1B, do they count the H4s? No, they don't count the H4s. Why are they counting the family members in the green card application? Because out of the 140,000 green cards that are available, we're only getting to use about 65,000 green cards. What's happening to the rest of the things? They are counting the family members. So if they stop counting the family members, the numbers will move from 140,000 to approximately 300,000. That definitely is going to relieve a lot of people, and the project date might move very quickly to the current, if not to about 2020, 2021. So please support these two provisions. We are drafting these letters for you to use it.
All right, Maruthi says, I have a valid H1B visa stamp till February 2024 and a new I-797 approval notice with a new company valid till October 2025. If I'm traveling to India this summer, do I need to go for stamping or can I return with the current visa? So you can return with the current visa, even though it has the old employer's name on it. When you're at the port of entry, though, you have to show both that visa and the new I-797 approval notice with your new company. because you need to make sure that they give you the end date that matches your new company's approval. Sometimes the officers will only look at your visa stamp and give you the end date in February 2024, matching your visa stamp. They are supposed to give you the end date on your I-797. And so you need to make sure to check that first and go online on the I-94 website and verify that you get the correct end date when you travel that way.
What happens to my EAD if I don't receive my AP renewal approval after 6 months for filing? Well, that's fine. It won't negatively impact your EAD application. You're in good shape. The EAD has this rule, at least right now, the 540 days extension when the EAD extension is pending. So you're good to work for 540-day rule if you file your application before the end of this year. After that, there is a 180-day rule extension that's available in general, but for now it's 540 days. So just because your advance parole is not approved, that's fine. You can continue working on the EAD extension. Anything else, Emily?
I think we are out of time for today. Thanks so much for joining us. As usual, we'll be back every Tuesday at 5 o'clock Central Time live to give you the latest updates and answer your questions. And don't forget, you can go to rnlawgroup.com and subscribe to our newsletter and also get our schedule for our daily conference call that we have for free as a resource to you.
Thank you very much.